and welcome to the daily newspaper analysis, which is brought to you by LawSikho. Today we have an editorial from the Hindu newspaper, which is titled as The Way to End Child Marriages. It is rather a very interesting read, though similar topics have been discussed previously as well. Let's see what we'll have over here. Then we have the news updates and legal news for the day. So this article, that is a way to end the child marriage, says that the government of India has stated that increasing the marriageable age of women will solve the issue of child marriage. Now, as we all know, that the marriageable age for women has been raised from 18 to 21, which means that for boys and girls both, now in India, the legal age for marriage is 21 each. So the benefit of increasing the age of marriage can now be held in sharp contrast against the National Family Health Survey 5 data. And it says that along with, increasing the marriageable age for women, there are some other steps also that we are required to take in order to accrue the highest or the optimal benefit of increasing this marriageable age. Firstly, let's understand what are the structural factors that are associated with it. So empirical studies, basically the studies that are based on numbers, data, and statistics from South Asia, establish relation between early marriage and adverse health and educational outcome for women. Now, of course, there are two things that are primarily associated with the early child marriage. Firstly is the health, and secondly is the educational status. See, when the body is only in the adolescent stage, or even if it has not even touched the adolescence period, so what happens is that the person, specifically here, if we talk about a girl, her body is not well enough, or it's not equipped enough well, and then we can say biologically, health wise as well, to take a lot of burden. It could be, the physical one, the psychological one, the mental one, etc. And thus, if in this case, if she bears a child, then the situation becomes even worse. So adverse health is associated with the early age of the girl, and of course the outcome for education will be hampered as well, because that is a particular time for going to school, for taking education. And instead of doing that, if a child, specifically here if we are talking about a girl, she's engaged into an institution like marriage, of course her educational status will have to suffer. So it also accounts for higher mortality of mothers, as we just were talking, that if at all there is a case of pregnancy, if she bears a child, so the risk for her health increases to manyfold. Poor nutritional health and educational outcomes of children. This is further abetted by social norms, poverty, and women's education, as we were just discussing. And it says that child marriage has only fractionally reduced marginally. It has instead of being marginal any change to 25% in National Family Health Survey 5 since NFHS 4, that is 28%. So only 3% of the child marriages have fractionally reduced. Let's talk about the educational outcomes. So significant number of child marriages take place for women with less than 12 years of education. Now, as you know, that 12 years is a significant period when a student is in school. But at this time, if a child gets married, a girl gets married, so of course, in majority of the cases, she drops off from the school, and that is why the significant number of child marriages lead to educational outcomes coming down as well. So hence an increase in schooling time goes hand in hand with increase in marriageable age. Though yes, of course, we can say that even 12 years is still 6 years younger than 18 years, which was the earlier age for marriage, the legal one. So how much impact will it actually have if we have increased the age for 21 as well? See, definitely this can be an argument, but at least now we have a legal backing, and the schools, the authorities, the institutions also have to come forward to make sure that no students are dropping off for such reasons, and that even the girl child is getting the most benefits out of the education system. So this article also talks about the way forward, wherein it says that health benefits must be made sure along with increasing the marriageable age, wherein we should be paying attention on the nutritional health as well as nutritional growth of our children. For example, we have Poshan Abhiyan, Ayushman Bharat, etc., that would make sure that with the increasing the age of marriage, we're also making sure that we are bringing in the health benefits for all the children, and specifically here for the girl child. Secondly, financial burden of marriageability has to be reduced, because in India, the one of the reasons for female feticide also, guys, is that we think that we will have to get this girl married and we'll have to give loads of gifts, what we call as the dowry to the girl. And that is why marriage is, instead of just a union between two people and families, rather it is taken as a big business deal, wherein there is a lot of financial burden that comes on the family of the girl. And that is why this financial burden must be reduced so that we can enhance it to the further, for the benefit of the society. Thirdly, women's education and skill management will have to be drastically improved. Yes, of course, because when we're talking about the education, merely education without any skill set will not, generate or will not convert into or will not realize into the employability of the girl child. And that is why we need to make sure that we are working on the health, we're working on the education, and at the same time we're also making sure that we are giving the right and the needed skills to the women for their employability in the society. And it says that in absence of these, the increase in the age of marriage may turn out to be counterproductive, and there will be nothing as such great benefit that we might might be able to reap out of this. And that is why we have to make sure that we are working in a multi-dimensional and a multi-modal method over here. With this, let's see what do we have for news updates today. Firstly, Dwishatabdi Mahotsav of Mumbai Samachar. So Prime Minister Narendra Modi participated in the Dwishatabdi Mahotsav of Mumbai Samachar in Mumbai. He also released a postal stamp to commemorate the occasion. The occasion celebrated the continuous publication of the Mumbai Samachar newspaper for 200 years. Secondly, government announced Agnipath reform. So the Defence Minister Rajnath Singh announced the Agnipath scheme as approved by the Union Cabinet for recruitment of youth in the armed forces for 4 years. The process of recruitment will commence in 90 days with a planned intake of about 46,000 young men and women this year. Thirdly, India qualified for Football Asian Cup. The Indian men's football team has qualified for the AFC, that is the Asian Cup 2023, even before the opening whistle of the final third round qualifier match against Hong Kong. This is also the first time that India had qualified for 2 successive editions of the Asian Cup. Fourthly, IPL media rights sold to Disney and Viacom 18. So IPL media rights have been sold to Star India, Viacom 18 and Times Internet for 48,390 crores for 5 years. Fifthly, first Bharat Gaurav train service flagged off. So the first ever service of the theme-based Bharat Gaurav train started its journey from Coimbatore north to Sainagar Shirdi. It was flagged off by the Southern Railway Salem Division manager Gautam Srinivas. Now let's see what do we have for legal updates today. Firstly, the court can pass an order of interim measures under Section 9 of the Arbitration and Conciliation Act against a third party, reiterates the Bombay High Court. So in the case of Choice Developers versus Pantnagar Pearl CHS Limited and others, the Bombay High Court has reiterated that the court is free to pass an order under Section 9 of the Arbitration and Conciliation Act to grant interim measures of protection against a third party who is impleaded in the petition filed under Section 9. The bench held that minority members of the society cannot act against the will of the majority. Secondly, accused taking plea of self-defense need not prove it beyond reasonable doubt, says the Supreme Court. So the Supreme Court observed in the case of Mahadev versus Director General Border Security Force, that if an accused who takes up the plea of self-defense need not so in that case, he need not prove it beyond reasonable doubt, and it would suffice if he could show preponderance of probabilities. So this was all for today. We hope you liked it. If you did, you may like the session. Also, you may subscribe to the channel. If you wish to download the PDF of today's slides, you can join our Telegram channel. The link is there in the description box below. Thank you so much.